Welcome to another deep dive. This time, we're going to be exploring a topic that, well, let's face it, nobody really wants to think about, but that's vitally important for all of us: wills and estate administration.
It's certainly not the most cheerful topic, but you're absolutely right. It is important.
And you've provided us with a really thorough collection of legal texts to delve into. So, our mission today is to distill all of that information, pull out the key takeaways, and hopefully uncover some interesting insights along the way so that our listener can get a solid grasp of this whole area without getting bogged down in the legalese.
Exactly. And what's fascinating, just glancing through your materials, is the sheer scope of what we're dealing with. We've got everything from the very basic definition of a will, what it is, why it's important, to the practical steps involved in actually managing an estate after someone passes away.
Right, the nuts and bolts of it all.
Yeah, and then we even get into some of the trickier ethical issues that legal professionals who work in this field have to navigate.
So it's more than just dry legal procedures.
Oh, much more. It's about people's lives, their relationships, their wishes, and ultimately how those wishes are carried out, or sometimes how they're not.
So let's start right at the beginning. When we talk about wills and estate administration, what are we really talking about? What's the essence of it all for our listener out there who might not be familiar with these terms?
Okay, well, in simple terms, a will is a legal document. It's a way for someone to officially declare how they want their assets to be dealt with after they die. And by assets, we mean their property, their money, their possessions, really anything of value that they own. Sometimes it even includes arrangements for things like guardianship of minor children.
So it's all about putting your affairs in order, essentially.
Exactly. And estate administration, that's the process that kicks in after someone dies.
Yeah.
It involves figuring out exactly what they owned, how much it's all worth, paying off any debts or taxes that they owed, and then finally distributing whatever's left over to the people who are named in the will, or, if there isn't a valid will, according to specific legal rules.
You mentioned there being rules if someone dies without a will. We'll definitely get to that. But first, let's talk about the key players involved in this whole process, because your sources mention a few specific terms that are important to understand. Words like testator, executor, and administrator.
Right, well, the testator, that's the legal term for the person who is making the will. They're the one whose wishes we're trying to honor, so to speak. If the testator names someone in their will to carry out those wishes, that person is called the executor. They're chosen by the testator themselves to manage the estate.
Okay, so the executor is essentially in charge of making sure everything happens according to the will.
Exactly. Now, if there's no will, or if the named executor can't or doesn't want to act for whatever reason, then the court will step in and appoint someone to handle the estate, and that person is called the administrator.
So the administrator steps in when there's no designated executor.
Precisely. And this whole process of the court officially recognizing a will as valid and giving the executor the legal authority to act, that's called probate. You'll often see the term grant of representation, which is the actual document confirming this authority. For executors, it's the grant of probate, and for administrators, it's letters of administration.
Okay, that makes those rules much clearer. Now, there's obviously a whole legal framework behind all of this. What are the main pieces of legislation that underpin wills and estate administration?
There are actually quite a few acts involved, but some are more foundational than others. Surprisingly, perhaps, the Wills Act of 1837 is still the cornerstone. It sets out the essential requirements for making a will that's actually legally valid, like the need for witnesses, for example.
Witnesses. Why is that so crucial?
Well, it's all about preventing potential fraud. The idea is that having two independent witnesses present when the testator signs their will makes it much harder for someone to forge a will or claim that the testator was pressured into signing something they didn't want to.
That makes a lot of sense. What other key acts should we be aware of?
The Administration of Estates Act of 1925 is another big one. It basically lays out how an estate should be managed after someone dies. It covers things like the order in which guests should be paid and how the assets are distributed if there's no will. Then there's the Inheritance Provision for Family Independence Act of 1975, which gives certain people who might not have been adequately provided for in a will the right to make a claim against the estate.
So it offers some protection for those who might have been overlooked.
Exactly. We also have the Mental Capacity Act of 2005. This one's really important because it provides a legal framework for assessing whether someone actually had the mental capacity to understand what they were doing when they made their will. Capacity is absolutely essential for a will to be valid.
Right, so it's not just about being of a certain age, it's about having the mental ability to make those decisions.
Exactly. And then finally, we have the Trustee Acts, primarily from 1925 and 2000. These govern the responsibilities and powers of trustees, which can become relevant if a will sets up ongoing trusts for beneficiaries.
Okay, so there's a lot of legislation to navigate. That's where solicitors come in. And your sources really highlight the importance of seeking legal advice in this whole area.
Oh, absolutely. Solicitors are the experts who can guide you through this complex legal maze. They're crucial when it comes to drafting wills, making sure everything is legally sound, and that the will accurately reflects the testator's wishes. They can also advise on all sorts of things that people might not even think about.
Like what kind of things?
Well, for instance, who can act as a witness to the will? There are actually specific rules about that, or the potential implications of different types of gifts that can be included in a will. It's not always as straightforward as it seems.
Right. Because you might think you're being very clear in your will, but legally it might be interpreted differently.
Precisely. And of course, solicitors also handle the often complicated process of estate administration after someone dies, which includes applying for that grant of representation we mentioned, dealing with inheritance tax, and ultimately ensuring that the assets are distributed correctly to the beneficiaries.
And your sources also place a big emphasis on the ethical standards that solicitors have to uphold in this area. Honesty, integrity, avoiding conflicts of interest, it's all taken very seriously.
It has to be. Solicitors have a fundamental duty to act in the best interests of their clients. This includes maintaining strict confidentiality and being incredibly careful about any situation where their own interests might even appear to conflict with their duty to the client.
And one specific example that comes up in the sources is the issue of solicitors receiving gifts from clients in their wills. That seems like a very tricky area.
It can be. There's specific guidance from the Solicitors Regulation Authority, the SRA, about this. Basically, if a client wants to leave a gift that's considered significant value to their solicitor or to a member of their family, the solicitor generally has to refuse to act unless the client gets independent legal advice from a different solicitor. It's all about ensuring there's no perception of undue influence.
So, significant value, is there a specific amount that triggers this?
No, it's not quite that simple. It's judged on a case-by-case basis, taking into account the overall value of the estate and the nature of the gift itself. The SRA gives some examples in their guidance, though. Things like substantial cash gifts, valuable assets, or gifts that would create an unequal distribution among family members, those are likely to be considered significant.
Okay, let's move on and focus on the will itself for a bit. What are the absolute essentials that make a will legally valid? It's more than just writing something down and signing it, right?
Right. There are three key elements that have to be in place: capacity, intention, and formalities. Capacity means that the person making the will, the testator, must have the mental ability to understand what they're doing. This isn't just about knowing they're signing a piece of paper. They need to understand that they're creating a legal document that will determine how their assets are distributed after their death. They need to understand the extent of their property and who their potential beneficiaries are. This all goes back to a really important case, Banks v. Goodfellow from 1870, which set out these principles. Now, those principles are also reflected in the Mental Capacity Act 2005, as we discussed earlier.
So capacity is about having a clear understanding of the implications. What about intention?
Intention means that the testator must genuinely want to create a will and must be doing so freely, without any pressure or coercion from anyone else. If there's evidence that they were threatened or forced into making the will, or that someone unduly influenced them, then the will could be challenged and potentially declared invalid.
Okay, so capacity is about understanding, and intention is about free will. What about those formalities you mentioned?
The formalities are the specific legal requirements that have to be met for a will to be valid. And these are laid out very clearly in the Wills Act 1837.
So what are those requirements?
First, the will has to be in writing. No verbal wills or anything like that.
Right, so it has to be a physical document.
Yes. And it has to be signed by the testator or by someone else acting on their behalf and in their presence with their specific direction. But here's the crucial bit. That signature must be witnessed by two people. And both witnesses have to be over the age of 18 and present at the same time when the testator signs. They can't sign later or separately. It's got to be a joint act.
Your sources also mention an attestation clause. What's that all about?
The attestation clause is a standard paragraph that's usually included at the end of a will, and it basically confirms that all those witnessing requirements were met correctly. It states that the testator signed the will in the presence of both witnesses, and then the witnesses signed it in the testator's presence. It's not strictly essential to have this clause for a will to be valid, but its absence can raise questions about whether the will was properly executed.
So it's best practice to include it.
Absolutely. It's one of those things that can save a lot of headaches down the line.
What if someone makes a will and then later wants to make changes to it? Can they just cross things out and add things in?
It's not quite that straightforward, unfortunately. Generally, any changes that are made to a will after it's been properly signed and witnessed are not legally valid unless those changes themselves are also executed with the same formalities as the original will. So they need to be signed by the testator and witnessed by those two independent people again. If changes need to be made before the will is signed, that's easier. Just make the changes clearly and have the testator initial them when they sign the will itself.
And what about a codicil? I've heard that term used in relation to changes to wills.
A codicil is basically a separate document that amends or adds to an existing will. It doesn't replace the original will entirely, it just makes specific changes. Maybe a new gift is added, or an executor is changed, or a clause needs to be clarified.
So it's like an update or an amendment.
Exactly. And importantly, just like the original will, a codicil has to be signed and witnessed with the same legal formalities for it to be valid.
So no shortcuts when it comes to making changes to a will.
Right. It's all about making sure that the testator's intentions are clear and legally binding.
Now, what if someone decides they want to completely get rid of their current will? How is a will revoked?
There are a few ways to do this legally. The most straightforward way is to simply make a new will. The new will should explicitly state that all previous wills are revoked, just to be absolutely clear.
So it supersedes the old one.
Exactly. You can also revoke a will by making a written declaration that clearly states your intention to revoke it. This declaration has to be signed and witnessed in the same way as a will, though.
So again, those formalities are crucial.
Absolutely. And finally, you can revoke a will by physically destroying it, burning it, tearing it up, shredding it, anything that clearly demonstrates your intention to revoke it.
And what about these mutual wills that your sources mentioned? That sounds intriguing.
Mutual wills are typically made by two people, often spouses or partners, who agree not to revoke or change their wills without each other's consent. It's a way of ensuring that their estates will be distributed in a certain way even after one of them dies. They often involve leaving their estates to each other initially and then to specific beneficiaries, perhaps children from a previous relationship.
So it's a way of making a joint commitment.
Exactly. And once the first person dies, the survivor is usually bound by that agreement. They can't just change their mind and make a new will that goes against what they originally agreed to. A court might even step in to enforce that original agreement.
That makes sense. Now, what about major life events? Do things like getting married or divorced automatically invalidate an existing will?
It depends. In most cases, getting married will automatically revoke any will that was made before the marriage. There is an exception if the will specifically states that it was made in contemplation of that particular marriage. But in general, it's assumed that getting married significantly changes your circumstances and that you'll want to make a new will to reflect your new family situation.
What about divorce?
Divorce, or the dissolution of a civil partnership, that has a slightly different effect. It doesn't automatically revoke the entire will, but it treats the former spouse or civil partner as if they had died on the date of the divorce or dissolution.
So it essentially writes them out of the will.
Exactly. They can't act as an executor, and any gifts left to them in the will would fail unless the will specifically states otherwise. It's important to note that this only applies to a legal divorce or dissolution. Just separating from your spouse or partner doesn't have the same legal effect on your will.
Okay, so we've covered how wills are made, changed, and ended. Now let's get into the nitty-gritty of what's actually in a will, the different types of gifts that people can leave.
Right, because there are actually several different categories of gifts, and understanding these distinctions is crucial when it comes to interpreting a will and making sure the testator's wishes are carried out correctly.
So what are the main types of gifts?
Okay, first we have specific gifts. These are gifts of particular identifiable items, things like my grandfather's gold watch or the painting of the countryside hanging in the living room. It has to be a specific, unique item.
So it can't just be any gold watch, it has to be that specific one.
Exactly. And this is where the concept of redemption by extinction comes in. If that specific item is no longer owned by the testator when they die, maybe they sold it or it was lost or destroyed, then the gift fails. The intended beneficiary doesn't get anything in its place.
So if the watch isn't in the estate, tough luck.
Essentially, yes. Unless the will includes some alternative provision, the gift is simply deemed.
Okay. What other types of gifts are there?
Then we have general gifts. These are less specific. They're gifts of a category of asset or a certain amount of money, but not tied to any particular item, like a blue car or 5,000 pounds.
So if the testator didn't actually own a blue car when they died, what happens then?
In that case, the executor would usually be obligated to purchase a blue car using funds from the estate to fulfill that gift.
So the intention is still carried out even if the specific item doesn't exist.
Exactly. Then we have demonstrative gifts. These are kind of a hybrid between specific and general gifts. The gift of a specific amount of money, but the testator indicates it should come from a particular source,
For example.
like 10,000 pounds from my savings account at Barclays Bank.
Okay, so it's tied to a source but not to a specific individual item.
Exactly. Now, if that particular source doesn't have enough funds to cover the full amount, the remainder can usually be paid from the general assets of the estate.
And what if that source doesn't exist at all anymore? Say the bank account was closed.
Then the gift would usually be treated as a general gift and paid from the general assets of the estate.
Okay, that makes sense. What other types of gifts are there?
We also have pecuniary gifts, which are simply gifts of fixed sums of money. These are paid out of the estate's assets. And then finally, there's the residuary gift. This is essentially everything that's left over after all the debts, taxes, administrative expenses, and all the other specific, general, and demonstrative gifts have been paid out.
So the residuary beneficiary gets whatever's left at the end.
Exactly. And that residuary gift can be left to one person or divided among several beneficiaries as the testator chooses.
Now, your sources outline a number of reasons why a gift that's been specified in a will might actually fail. They call this failure of gifts.
Yeah.
What are some of those reasons?
Right. Well, one reason is simply uncertainty. If the wording in the will is unclear, either about who the gift is intended for or what exactly is being gifted, then the gift might fail. The court might try to figure out the testator's intentions, but if it's just too vague, the gift could be deemed invalid.
So it's crucial to be very clear and specific in the wording of the will.
Absolutely. Precision is key. Another reason for failure is if a beneficiary of the will also acts as a witness to the will.
That seems like a conflict of interest.
It is. The law prevents beneficiaries or their spouses or civil partners from acting as witnesses to the will because it creates a potential for undue influence. If they do act as a witness, then any gift to them in the will is invalid.
Okay, so you can't benefit from a will that you also witnessed.
Exactly. Now, the rest of the will can still be valid as long as there are at least two other valid witnesses, but the gift to that particular beneficiary would fail.
What happens if a beneficiary dies before the person who made the will? Does the gift just disappear?
That's called a lapse, and in most cases, yes, the gift would fail. It would usually fall into the residuary estate and be distributed along with the rest of the remaining assets. However, many wills will include what's called a substitutional gift, which names an alternative beneficiary who should receive the gift if the original beneficiary dies before the testator.
So it's like a backup plan.
Exactly. And there's also this concept of a disclaimer. This is where a beneficiary actually chooses to refuse to accept a gift.
Why would someone do that?
There could be various reasons. Maybe they feel they don't need the gift, or they want it to go to someone else, or there could be tax implications. Whatever the reason, if they formally disclaim the gift, it's treated legally as if they died before the testator, and the gift would then usually pass to their children, or to whoever is named as a substitute beneficiary in the will, or if neither of those apply, it falls into the residue.
Okay, that's interesting. Now, we discussed redemption earlier in the context of specific gifts, but it also applies more broadly to gifts failing because the testator no longer owns the asset.
Right. So if any gift, not just a specific gift, is no longer part of the testator's estate when they die because it was sold, given away, lost, or destroyed, then the gift fails. It's deemed. And remember, the timing is crucial. It has to be disposed of before the testator's death.
And just to clarify, if the asset has essentially just changed its form, but it's still effectively the same asset, does that count as redemption?
That can be a tricky area, and it often comes down to the specific wording in the will and the intentions of the testator. For instance, if someone leaves my shares in Company X, and then Company X merges with another company, it becomes Company Y, the gift wouldn't necessarily be deemed because the underlying asset is still there, it's just changed its name. But if they leave my 100 shares in Company X and then sell those shares and buy different shares in Company Y, that's more likely to be seen as redemption because the specific asset is gone. It's all about looking at the substance of the change, not just the form. And remember, codicils can play a role here. If a codicil republishes the will with a new date, it can sometimes affect how the rules of ademption apply. It's all very technical and fact-specific.
This is getting complex. And then there's that last reason for a gift to fail, forfeiture.
Yes. Forfeiture is based on the principle that you shouldn't be allowed to benefit from your own wrongdoing, specifically from unlawfully killing someone. So if a beneficiary murders or unlawfully kills the testator, they're not allowed to inherit from them.
So they're essentially disinherited by their own actions.
Exactly. They're treated as if they died before the testator. Now, there are some exceptions to this rule. For example, if the killer was legally insane at the time of the act, or if they were convicted of manslaughter rather than murder, the court might have some discretion in applying the forfeiture rule. There's also a specific provision in the Forfeiture Act 1982 that allows the court to modify the effect of this rule in certain cases.
Okay, so there is some potential for flexibility in exceptional circumstances.
Right. And it's worth remembering that these cases can be very complex and fact-dependent. Your sources even mention the case Ninian v. Findlay from 2019, where a wife who helped her terminally ill husband commit suicide was still allowed to inherit from him. The court determined that her actions didn't amount to encouraging his death, and the criminal charges against her were dropped.
So even in cases of assisted suicide, the application of the forfeiture rule isn't always straightforward.
Exactly. It highlights the importance of careful consideration and legal advice in these sensitive situations.
Let's shift gears now and talk about what happens after someone dies. Who actually takes charge of managing their estate?
That's where the personal representatives come in. This is a general term that covers both executors and administrators. As we discussed earlier, executors are the people named in the will to carry out the testator's wishes, while administrators are appointed by the court when there's no will, or when the named executors can't act.
Right, so they're the ones responsible for the whole process of estate administration.
Exactly. And their responsibilities are quite extensive. They have to obtain the legal authority to act, which means getting the grant of probate for executors or letters of administration for administrators. They need to identify and collect all of the deceased's assets, pay any outstanding debts and taxes, and ultimately distribute the remaining assets to the beneficiaries, according to the will or the rules of intestacy.
It sounds like a big job.
It can be, especially for larger estates or if there are complications. And just to clarify, there's usually a limit of 4 executors who can act at any one time, even if the will names more than that.
Okay, so there's a cap on how many executors can be involved. Now, what if someone is named as an executor but doesn't actually want to do it?
They have the option to formally renounce their role. But this has to be done before they've started doing anything on behalf of the estate. Once they formally renounce, they can't change their mind later. There's also something called reservation of power, which allows an executor to step aside temporarily, maybe because they're busy with other things, but retain the right to come back later if needed.
So there's some flexibility there. What happens if a personal representative dies while they're still in the process of administering the estate?
Well, if there are other personal representatives, they would just continue with the administration. If the sole remaining personal representative dies after getting the grant of probate or letters of administration, the court will likely need to appoint a replacement. And if the sole personal representative dies before even getting the grant, then someone else will have to apply to the court to take over. There's also this principle called the chain of representation, where if an executor dies and has their own executor, that executor can sometimes step in to administer the original estate as well. But it gets quite complex, especially if there are minor beneficiaries or significant assets involved.
Right, so it's best to have a backup plan in place.
Absolutely. And if none of these situations apply, then it might be necessary to apply for a special kind of grant called a granta bonus non administratis, which is specifically for administering the remaining parts of an estate.
What kind of powers do personal representatives actually have to manage the estate?
They have a range of powers granted to them by law. They can invest any trust funds, although they generally can't invest in land without specific authorization. They can, however, purchase land in the UK if it's deemed necessary for the administration of the estate. And they also have the power to sell personal property belonging to the deceased to cover debts, taxes, and any cash gifts left in the will. These powers are all designed to help them manage and distribute the estate effectively.
Speaking of debts and payments, is there a set order in which liabilities are paid out from the estate?
Yes, there's a very specific order that personal representatives have to follow. First in line is any loan that was specifically taken out to pay inheritance tax. Then comes the funeral expenses and the testamentary expenses, which are the costs associated with actually administering the estate itself. After those priority payments, other debts owed by the deceased are paid. It's generally best to pay these from the residuary estate rather than by selling off specific gifts that the testator intended for particular beneficiaries. And then, only once all the debts and liabilities have been settled can the personal representative start distributing the gifts to the beneficiaries, followed by the remaining residuary estate.
So how does the process of actually selling assets and distributing the estate work in practice?
Well, when it comes to selling assets, the first step is getting an accurate valuation. Then the personal representatives decide which assets need to be sold to cover the estate's liabilities. Once those decisions are made, they can go ahead and execute the sale, making sure everything is done legally and properly documented. The proceeds from the sale are then used to settle the estate's obligations. Funeral costs and inheritance tax come first, then any other debts, and then any cash gifts left in the will. Once all those obligations are taken care of, the remaining assets are ready to be distributed to the beneficiaries. This involves carefully identifying all the beneficiaries, allocating the correct gifts to each one, and actually transferring those assets, which might involve legal transfers of ownership for things like property or shares.
So there's a lot of paperwork and legal procedures involved.
Oh, absolutely. It's a meticulous process, and keeping accurate records of everything is essential.
So when is this whole process of estate administration considered finished? When can the personal representative say their job is done?
Essentially, it's considered complete when all the assets have been gathered, all the debts and taxes have been paid, and all the remaining assets have been distributed to the right people. If the will set up ongoing trusts for beneficiaries, those trusts can also be terminated under certain circumstances, but that usually requires the consent of all the beneficiaries who have an interest in the trust, and there are legal formalities to follow.
Are there any final tasks for the personal representatives once everything's been distributed?
Yes, they should usually prepare detailed estate accounts for the residuary beneficiaries. These accounts basically summarize everything that's happened with the estate, all the assets and debts, all the expenses that were paid, all the legacies that were distributed, and what's left over in the residue. It's all about transparency and making sure the beneficiaries understand how the estate has been managed.
And what about the rights of the beneficiaries themselves? Do they have any say in how things are done?
Beneficiaries have several important rights. They have a right to receive information about the progress of the estate administration, to see an accounting of how the estate's being managed, and if a trust is involved, to inspect relevant trust documents. They also have the right to make sure the terms of the will or the rules of intestacy are being followed correctly, and to receive their inheritance without unnecessary delays.
So they're not just passive recipients, they have legal rights.
Exactly. And the law provides ways for them to enforce those rights, including going to court if necessary. They might even have the right to consent to certain decisions made by the trustees, to request specific information, or even to apply to the court to change the terms of a trust in certain circumstances.
What happens if some of the beneficiaries can't be found?
Personal representatives have a duty to make reasonable efforts to find all the beneficiaries. One common way to do this is to place notices in newspapers, following the procedure set out in the Trustee Act in 1925. These notices basically ask any potential beneficiaries to come forward within a certain time limit, usually 2 months. If they do that and no one comes forward, they're generally protected from any claims later on. But this only applies to beneficiaries they genuinely didn't know about. If they knew about a beneficiary but just lost contact with them, that's a different matter.
So they need to be thorough in their searches.
Absolutely. And for beneficiaries they know about but can't locate, they might need to consider other options, like getting indemnity insurance or asking the court for directions on how to handle the situation.
Now, you mentioned earlier that the Inheritance Provision for Family and Dependents Act 1975 offers some protection for people who might have been left out of a will or not adequately provided for. Can you elaborate on that?
Right. This act is a kind of safety net. It allows certain people who were close to the deceased, like spouses, children, or financial dependents, to make a claim against the estate if they believe they haven't been treated fairly.
So even if they weren't included in the will, they might still be able to get something.
Exactly. The court will look at various factors, like the applicant's financial needs, the size of the estate, and the needs of other beneficiaries, and then decide whether to award them something from the estate. There are strict time limits for making these claims, though, usually within 6 months of the grant of probate or letters of administration being issued.
Okay, that's important to know. Now, let's talk about what happens when someone dies without making a will at all. Your sources outline the rules of intestacy that apply in these situations.
Right. When someone dies intestate, meaning without a valid will, the law steps in and dictates who inherits their estate. There's a very specific order of priority. First comes the surviving spouse or civil partner. Then it's the deceased's children and their descendants, like grandchildren. If there's no spouse or children, it goes to the parents, then siblings, then grandparents, then aunts and uncles. And as a last resort, if there are no relatives who qualify, the entire estate goes to the crown.
So there's a clear hierarchy. And what about unmarried partners or stepchildren? Do they inherit anything?
Unfortunately, no. Under the current rules of intestacy, they don't have any automatic right to inherit. Adopted children, however, are treated the same as biological children for inheritance purposes.
Okay, so those family relationships aren't legally recognized in the same way.
Exactly. And it's really important for people to be aware of this, especially if they're in an unmarried relationship or if they have stepchildren who they want to provide for. Making a will is the only way to ensure that their wishes are carried out.
So let's say there is a surviving spouse. What exactly do they inherit?
The rules changed relatively recently, so it depends when the person died. But for deaths after July 26, 2023, if there is a surviving spouse or civil partner, they inherit all of the deceased's personal belongings, things like furniture, clothes, and jewelry, but not things like money or investments. They also get a fixed lump sum, which is currently set at £322,000. And then, if there's any remaining estate after those are taken out, the surviving spouse gets half of it, and the other half is held in trust for the deceased's children.
Okay, so the spouse is taken care of, and there's provision for the children.
Exactly. And there's one crucial detail here. The spouse or civil partner has to survive the deceased by at least 28 days to be eligible to inherit anything under these rules.
So it's not just about being married, it's about outliving them by a certain period.
Exactly. And if there are no children, then the surviving spouse gets the whole estate, as long as the death occurred after October 1st, 2014.
Okay, that makes sense. What about if there are children but no surviving spouse?
In that case, the entire estate is divided equally among the children. If a child has already died but has their own children, those grandchildren would inherit their parents.